This podcast will introduce you to a key aspect of conducting legal research and will offer help in writing a legally relevant text. We will talk about how to research for and use primary sources of law. First, we address the question of what do we mean by primary sources. One of the key elements, and perhaps the most frustrating one about legal study, is the need to offer what is called authority for every single statement of law. Something is the law not because it makes sense or because the author references someone who says it does. Something is the law only because it is referenced in a legal text, statute, national or international legal, or found in a court case. These references, legal provisions and case law, are known as primary sources of law. When should you use case law or statutes? Students of law have, from very early on, get used to the idea of producing these very heavily referenced pieces of work that may look burdensome but are necessary when presenting legal material. If you're wondering when to offer these references, remember that you will have to, as mentioned earlier, offer a legal reference every time you write something that is interpreted as a statement of law. This is very important, otherwise you will be penalized in your assessment for not having clearly identified what the law is. You are probably convinced now that you need to offer citation of primary legal sources in your work, but where will you find them? Statutory material are easier to find as they will be highlighted in the textbook or guide that you're using as background reading for your research. The advantage of statutory sources, for instance, is that these are easy to locate authoritative sources. You can find legislation.gov.uk, for example, once you know what you're looking for. Where most students experience trouble is locating relevant case law. How do you find case law that shows how courts have interpreted legal provisions, or even better, a case that supports a point you're trying to make? The best way to find case law is to chase references you have found in your textbooks and guides. If this is not sufficient, then you can try some searches in specialized search engines like Google Scholar. Once you have some leads, you can locate the text of the case on the legal databases through the library website. Of course, you're welcome to try and use the search functions on the databases themselves, but be prepared for long lists of results that may be less focused than the ones from external search engines. If this sounds daunting, do not worry, as digital skills get better the further you progress in your study. Does it matter if you're looking for domestic or international content? One could legitimately wonder whether legal research skills differ from the national domain and what primary sources mean at this level. The answer is that while legal material will be in the form of international treaties and produced by supranational institutions, their use is very similar to domestic legislation. Same with case law, with the main difference that some of the jurisprudence produced by international tribunals does not operate as binding precedent for future ones, as in the English courts, for example. While admittedly searching for primary material in international law, think of determining the content of customary international law, for instance, is more complex than a similar process on the domestic level, the same techniques mentioned above will work for international legal material. For specific areas of study, please refer back to your module handbooks. What is very important is to reference your primary legal material properly. For this, you need to carefully consider the information on citation and referencing style as adopted by your modules. The law school uses Oscola. Oscola offers a method of ordering the information used to identify cases through footnotes. The best advice on the topic is that, yes, this is tedious, but if you keep your references on the appropriate style from the moment you first start taking notes at the beginning of your research, it will save you a lot of time afterwards. And remember to keep a record of where each source and each piece of information you intend to use in your essay came from. Once you've identified your primary sources of law, how many should you use? Students very often wonder how much law they should cite and when they have enough references. The answer to this stressful question has already been offered earlier. You need to use as many primary sources as the statements of law you're making. Therefore, you should never have less or more than the legal material that you're in fact presenting in your essay. In summary, in this podcast, we've introduced the concept of primary sources of law and discussed how to find and when and how to use them when researching international and national law material. Thank you for This podcast will introduce you to a key aspect of conducting legal research and will help in writing a legally relevant text. We will talk about how to research for, evaluate, and use secondary sources of law. What do we mean by secondary sources? Most essay questions in law ask you to critically evaluate, analyze, or discuss a particular topic or respond to a certain proposition. How do you do this, and whether you will do it in a way that satisfies your reader and results in a great mark, will depend on the quality of sources you use to inform your opinion and on the extent to which such opinion is securely substantiated. By secondary sources, we mean commentary that can be found in books, articles, in academic journals, chapters in books, reports, press pieces, and literature produced by institutions, NGOs, and private organizations. These offer explanation, opinion, and context on legal documents. Sources, therefore, aren't where the law is present in primary sources, but where the law is discussed in an effort to understand its consequences and operation. They contain an attempt to reflect on law's present and future trajectories. When to use secondary sources? When you're invited to critically evaluate, analyze, or discuss a particular topic or respond to a certain proposition, your reader understands that you cannot express purely personal opinions and impressions. In fact, you should not simply write what you think about the indicated topic. Remember that the aim of coursework and other assessment is for you to demonstrate your knowledge in a stylized way that shows how you meet the learning outcome specified for the particular assessment, and the module more widely. In doing that, you need to show that you know what's going on first, and that you have engaged with the relevant literature that critiques what's going on secondly. Using secondary sources of law allows you to exactly do this: engage with the literature. Your personal opinion is welcome, but only after you've shown your knowledge and understanding of the area in a more formal way. A good essay is positioned in between the two extremes of opinion without substantiation and simple description. Finally, remember that secondary sources are the result of someone's direct research, linking to data and empirical evidence way beyond what you can achieve on your own. This is why such commentary has weight and should be marshaled in support of your argument. How to find and quality control secondary sources. Finding and evaluating secondary sources is a key component to writing a successful essay. In an environment saturated with concern about fake news and biased information, however, it is more challenging than ever to evaluate and select appropriate sources in your research. The best way to structure your research and keep results relevant and genuine is to work from the handbook and module material in an incremental fashion. Your module provided resources are based on other bits of secondary sources. Looking for the references in your material will help you diversify your source content and broaden your searches. It is unlikely that you will be asked to look at a topic completely distinct from your studies, so following on from provided sources is always a good idea. If you are looking for secondary sources in a topic that is less familiar, perhaps for your dissertation, then you need to reach beyond the references that you have been provided with. After you exhaust any leads from the sources you've been already given, you can try some searches in specialized search engines like Google Scholar. Once you have some leads, you can locate the journal articles that are behind the paywall or on the legal databases through the library website. Be mindful, however, that the search functions on the databases are less efficient than Google when searching with keywords. Once you have a few leads that you know are relevant and authoritative, you can again utilize the literature they're based on. Look at your sources' references in order to generate additional information. Despite a general impression of confusion and political bias, most information out there isn't serving a purpose other than to analyze and interpret reality. Books are not more authoritative than journal articles. Therefore, if you need to prioritize sources on the basis of research robustness, journal articles in peer-reviewed publications by major publishers tend to be reliable. Books and edited collections are also safe sources, albeit occasionally of less research intensity than journal articles. Reports and internal documents by institutions and organizations, public or commercial, need to be approached with more caution. A multinational writing about its own corporate social responsibility efforts, for example, may present a rosier picture than an NGO representing the views of those affected by its operations. Journalistic sources are those which require the greatest degree of caution. Not all newspapers are the same, and the fact that something is published online does not mean that it is way or form. Major print newspapers like the New York Times and semi-official news sites like the BBC tend to be better than tabloids, such as the Mirror. Exercise caution and common sense. Have you heard of Occam's razor? The simplest explanation is probably correct. Perhaps the belief that the world's leading media is participating in a complex global conspiracy while someone has independently discovered the truth and publishes it on a blog from their mom's basement isn't empirically robust enough for the blog to make it as a reference on your essay. Finally, avoid online dictionaries and Wikipedia, not because they are wrong, but because they're a lazy way to reference a point you're trying to make. Reference the literature establishing the point you're trying to make, and do not take shortcuts if you're aiming for better marks. How to cite sources. What is very important is to reference your legal material properly. Carefully consider the information on citation and referencing styles as adopted by your modules. The law school uses Oscola. Oscola offers a method of ordering the information used to identify cases through footnotes. The best advice on the topic is that yes, this is tedious, but if you keep your references on the appropriate style from the moment you first start taking notes at the beginning of your research, it will save you a lot of time afterwards. And remember to keep a record of where each source and each piece of information you intend to use in your essay came from. In summary, this podcast has introduced the concept of secondary sources of law and discussed how to find and when and how to use them when researching for coursework and dissertations. Thank you for your attention.